So what happens once you get the QME report? Well, as I told my students at law school for so many years, with so many things in the law, it depends. So if you get the QME report, you read through it and you have no disputes. Everything the QME said appears to be accurate with regards to your subjective complaints, your limitations, correctly noted any surgeries that you had, and reviewed the treatment reports in your case. If you have no disputes with it, and if the insurance company or their attorney has no disputes with it, they aren't fighting the level of whole person impairment or the apportionment, then conceivably you can move forward with settlement. That would either be moving forward with stipulations with request for award based on that QME report. It should be relatively straightforward if you're doing STIPs, because the level of impairment is going to be addressed in that report. So the QME found a level of whole person impairment, found apportionment, or at least discussed apportionment, and then that's going to rate out with a string rating. We have another video on that, using your age and occupation to the final level of permanent disability. That final level of permanent disability goes to a state chart, and the level of money, the amount of money for that level of permanent disability is fixed. So there's not a lot of negotiating that will take place there. However, if you dispute the QME report, so a couple of different ways. It depends on what it is in that QME report that you disagree with. Many times I've had clients, they note that there's some mistakes in the medical record review, or some of the subjective complaints aren't accurately recorded in the QME report. It doesn't necessarily matter, because what really matters is the level of whole person impairment and the apportionment that the QME found, because that's what goes into that final rating. So I've had QME reports for clients where there have been mistakes or omissions in the medical record review, let's say, or in the history, but it wouldn't affect the final level of permanent disability. In those cases, it just doesn't matter. If there are substantial errors, though, if the doctor said you didn't have surgery, but in fact you did have surgery, that can have a significant impact on the level of whole person impairment. So let's say you find mistakes and you need to get that clarified. The way that you generally do it is to put together a cover letter to the QME. You have to copy the insurance company, and what you're going to do is you need to copy either the insurance company or their attorney, send it to them with a cover letter and say, hey, I'm going to send this letter to the QME in 20 days. Let me know if you object. They have the right to object to any language that you have in the letter, and if there's a dispute, conceivably it might need to go to the board, but send it to the adjuster or the defense attorney. Wait 20 days. If you don't hear from them, then you can mail your letter to the QME, keep a copy of the letter for yourself, and you must send a copy of that letter to either the adjuster or their attorney. Then you can get a supplemental report from the QME, and when that report comes in, ideally it's correct and you can move on. Alternatively, let's say you get that initial QME report, you have no disputes with it, but the insurance company says, nah, the level of permanent disability is too high, or, oh, there's not enough apportionment. The injured worker, you had a car accident, 20 years ago, and the doctor didn't find apportionment. They can do the same sort of thing. They can put together a letter, send it to you, and they need to wait 20 days before they send it off to the QME. If you don't object, if there's no errors in there, no leading language, they can ask questions, but they can't confuse the doctor or put forth an inaccurate history or an incorrect interpretation of the law. If you have no objections, then they wait 20 days, they send the letter off, and they have to copy you with the letter. Then you get that report, and conceivably, then you move on to settle. The other alternative for discovery with a QME is generally a deposition. You don't generally find that with injured workers without attorneys. It's not something that takes place often in workers' compensation. Attorneys for the insurance company aren't generally comfortable doing that type of thing. Judges are often reluctant to entertain such an idea because the adjuster is not going to take the QME depo. It will be a defense attorney, probably someone who has a lot of experience, and then you're trying to represent yourself. and you just don't know, as an injured worker, you're not an attorney, you're not familiar with objections, you're not familiar with the type of questions that can be asked and should not be asked. So if it gets to the point of a deposition of the QME, my recommendation is that you really want to reach out to an attorney at that point. Try to find an attorney to represent you at that deposition. Beyond that, conceivably, if one of you, either you or the insurance company, still object to the QME reports, you've gotten a supplemental report or two, you're still upset, that can go to the board. There would be a mandatory settlement conference. A judge would review the issues with the parties and conceivably set it for trial. At that point, really, the only real fight that usually takes place is that the QME report isn't substantial medical evidence. It's either based on an incorrect history, based on a faulty or an incomplete examination. It's based on an incorrect interpretation of the law. At that point, again, you're going to be taking the case to trial. Again, my recommendation is reach out to an attorney, because going to trial, you're going to be going up against a defense attorney for the insurance company. The adjuster won't be showing up for that trial on her own or on his own. So that's it. When the QME report comes in, conceivably, you can move forward to settlement. If not, if one of the parties has a dispute, or if both of the parties are upset with the QME report, you can get supplemental reports. If you have any other questions, drop us a comment down below. If you like this video, hit the like button.